Estate planning with a solid last will and testament for LGBTQ plus families is absolutely vital. As you probably know, in the year 2015, same-sex marriage was legalized in all 50 states here in the United States. However, today about only half of couples in the United States who are LGBTQ plus are actually married. Regardless of whether or not you are an LGBTQ plus couple, if you are not married, there can be some horrible consequences if one of you gets sick or if one of you passes away, especially if there's children involved. What we see more often than not is that there is a child or children in a partnership, then usually one of the partners is the biological parent. Or what we actually see more often is that neither of the parents is the actual biological parents because they used a surrogate for their child or their children. If you have not legalized your partnership or your marriage, then there are several things that you need to be on the lookout for and you need to be aware of. You should have a solid estate plan in place to protect both you, your partner, and your children if anything were to happen. The first thing I already talked about, and that is children. It's so important to have planning for your children. The laws vary from state to state, but usually it is the biological parent who has priority and who actually has legal rights to the child. And this can create a problem if there's a divorce or a breakup in the partnership. Or more likely, it's healthcare decisions that need to be made on behalf of the child if the biological parent is the one who is incapacitated or who has already died. There needs to be an absolute plan in place ahead of time, whether that is through adoption, guardianship, or some other means that specifically states what happens to the children in an LGBTQ plus marriage or partnership. It's absolutely crucial to have this planning in place to protect you, your partner, and your children. The next thing is healthcare. We always hear about healthcare. All married couples enjoy pretty much standard rights as far as making decisions on behalf of their legal partner. However, people who are together with no legal documents in place most likely will have zero rights to decide what happens to their partner in the event of a healthcare crisis. We have actually seen this come up several times. Luckily, the families in those cases where we have seen it were extremely supportive of the partnership, and even though the family members are the ones who ultimately had to talk to the medical professionals, they did so as kind of a conduit of what the life partner really wanted. They were able to pass on those decisions to the medical professionals. Now, those are good situations where the families were involved and everybody was on board. That's a good situation. However, you can get into a situation where a couple has been living together for years and years, and something happens and medical personnel will not allow that person to make any decisions, or worse, even have access to their partner. It can become a really sticky situation very quickly. You really absolutely need to have your healthcare documents in place, specifying exactly who can make medical decisions on your behalf. The same thing goes for the next topic, and that is your finances. If you have not specifically given written authorization to your partner, allowing them to have access to your finances, then there is a really good chance that, well, they won't be able to access your finances. And that can put the healthy partner in a very bad situation where they're unable to access money to pay bills or even buy prescriptions, medicines for the partner who is sick. And the last thing goes along with what I just mentioned. What happens if one of the life partners actually dies? If there's not a plan in place, then the heirs are going to get everything, and that life partner is probably not an heir under the law. If their parents are still alive, then their parents could end up as the beneficiary of the entire estate and not the life partner. If they actually did have children as part of the relationship, then the children may be the heirs to the estate and not the partner. And you might say, well, that's okay if the children are the ones who inherit everything. But remember, if your life partner had no say in anything, then they are probably not going to have any say in that money and how it is spent for those children. You see where that can get into a very bad situation very quickly. We had a situation where the person was never married, never had children, his parents had died, his brothers and sisters had all died, and the only family left were dozens of cousins who he had actually never even met before in life. Under the laws of intestate succession, the cousins were entitled to his entire estate and not his life partner of over 30 years. You've heard me always say that you need to have an estate plan in place, and it's absolutely crucial for LGBT plus families to have an estate plan and a plan in place. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.